All righty, let's get started this morning. Welcome back, everyone, to Senate Judiciary. I'm going to dispense with the roll call. I think Lily can see that we're all here, and we'll get underway. It's good to see the Chief of Staff back there, a longtime chairman of this committee, and did a lot of great work for the Wyoming Senate. You are missed. I'm glad you are where you are, Chief, but you were missed where you used to be. So great to see you, Drew. Let's get started with Senate File 53. This is a bill committee. You'll remember that late in the year, the Chief Justice was able to go up and certify a facility up in Gillette, which was the contingency upon seating another judge there. A couple of years ago, our Appropriations Committee approved that position contingent upon a facility that was adequate enough to host, to be another quality courtroom. That has happened. Campbell County has stepped up. The county commissioners have supported that, and they have built a new chamber up there. So late in the year, the co-chairman and I decided that we should bring this just to make it official rather than having it go through the budget bill or whatever. And so that's why this bill is in front of you today, committee. I sent it out to members of the Judiciary Committee for whoever wanted to sign on. I will say that it is on one of those lists this morning I see where people don't want us to seat another judge. So I'm looking, I thought Ms. Butler was out in the hall. Oh, there you are on that side. I'm sorry, Lisa, would you be willing to come up and give us some thoughts about Senate File 53 and what brings us to today? Thank you. Sorry, I didn't see your.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. So, Mr. Chairman, I think you gave a pretty complete background of why this bill is in front of you today, but I'll just give you a little more context. In 2022, the legislature passed a bill to provide 3 new judge positions throughout the state. Those judge positions were in the 3rd Judicial District, which covers Lincoln, Sweetwater, and Uintah counties, the 7th Judicial District, which covers Natrona County, and then the 6th Judicial District, which covers Crook, Weston, and Campbell counties. So in the 3rd and the 7th Judicial District, there were already quarters available for a 4th District Court judge in those 2 locations. They had an office, a chambers, a courtroom, everything that the judge needed to just go ahead and take the bench. And so those 2 positions were funded immediately. In the 6th Judicial District, there was not suitable quarters available at that time. And so what the legislature did is in that bill, they required that the Chief Justice certify that there were suitable quarters for the position that was already provided before that position could be funded. So since that time, Campbell County has worked really hard to provide suitable quarters for a district court judge. The county commissioners there are very supportive. They spent the money to redo the courthouse to house a 4th judge in that district, and that those quarters are now available. The Chief Justice has certified that. One of the things that I want to impress upon the committee today is the availability of a 4th District Court judge in the 6th Judicial District will serve the citizens of Wyoming. So the purpose of seating a 4th judge in all 3 of those locations, all 3 of those judicial districts, is because in those locations, 3 judges were doing the work of 4. And so adding a 4th judge in all of those locations serves the citizens better because it allows them to get into court more quickly. What we were seeing in those locations is there were extended timelines from when, a complaint was filed to when a litigant could actually appear in the court. And that's just based on the fact that there are so many hours in a day that a judge can do the work of a judge. And so what this fourth judge, district court judge in the 6th Judicial District will do is it will provide expedited timelines for litigants. So they're not waiting quite so long to get into court. Right now, we're looking at years out, right? Years out for a trial. This will speed that up. I think they have seen that in the 2 locations where we have seated a fourth judge. So both the 7th and the 3rd have a 4th judge now. Judge Eames was seated in the 7th Judicial District. Judge Castee was seated in the 3rd Judicial District. They're both doing great work, and we are able to speed up those timelines. And so this really is a benefit to the citizens themselves. And Mr. Chairman, I'd be happy to answer any other questions that the committee may have.
Any questions, committee of Ms. Butler this morning? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. No, this isn't a question, but more of a comment. Just wanted to say that having that extra judge in my county has just been amazing, and he's doing great work. But it's made a difference on our other judge, that Judge Brunel, and I actually saw him smiling the other day, and I'm not sure I've seen that for years. So we appreciate the change that was made. Thank you.
So, Ms. Butler, you kind of answered a couple of the questions that I had. Just to refresh my memory, I remember the discussion, and we kind of joked around a little bit about it, but we literally had situations where people were told you can't get a divorce for the next 8 months. You have to stay together 8 more months. Can you imagine that? But so it really is all about justice. It's more than just spending the money for another judge. It's really about this justice piece, isn't it?
Mr. Chairman, that is correct. When we have 3 judges doing the work of 4, justice is delayed. As I said, there are only so many hours in a day that judges can hear cases. And when you have 3 doing the work of 4, what that means is those timelines are extended. And when you think about, especially civil cases like divorces, those generally, unfortunately, fall to the bottom of the pile because there are other kinds of cases that have to take precedence statutorily. Those are criminal cases, juvenile cases, Title 25 cases. Those all have statutory timelines built around them. And so when you talk about civil cases, and this happens a lot, I believe, in domestic relations cases, unfortunately, they move down the time because there are only so many hours in the day.
Thank you for that. Anything further from Ms. Butler, committee? Okay, thanks, Elisa. Really appreciate you being here.
Mr. Chairman.
Yeah, go ahead, Senator.
I apologize, but it might be helpful when we bring this to the floor to be able to discuss how we actually determine if a new judge is needed. I mean, in terms of workload and the case management system and kind of how that's figured out. That, we don't, when you have 4 judges, that doesn't mean that they all get Fridays off and they all meet on the golf course kind of thing. I mean, when we need a judge, there's data behind it.
That's a very good point, Senator. And there is paperwork, Ms. Butler, that you provided. I have a couple of very helpful pieces upstairs, but that would be helpful if you would be willing to go back those 2 years to when we considered and approved these positions. There was a reason. So maybe you have thoughts to share with Senator Case.
Mr. Chairman, Senator Case, absolutely. So what we do when we determine, there is data. And so when we look at the workload of the judges, we have what we call a workload study. And we've used that many times with the legislature before to ask for positions. We've actually done it this year for some of our circuit court clerks. So what the workload study, the process for the workload study is, when we create that study, the judges keep track of every minute of their day. So they're just like lawyers again, they have to bill time. And then we take those minutes and we separate them out into case categories. So like domestic relations cases, criminal cases, we separate them out into case categories. And you look at the average number of minutes it takes a judge to complete one of those kinds of cases from beginning to end. So, a felony case, I'm just pulling this out of the air because I don't have the numbers right in front of me at the moment, but a felony case takes, 500 minutes. I don't know if that's accurate or not. And so you plug in the number of filings each year, you multiply it by 500 minutes, and that's how we come up with the workload across the state. And so we have done that for many, many years. We've provided that workload study to the legislature, and it does give us a good picture of what the workload is throughout the state. We do that for district court judges, we do it for circuit court judges, and because the circuit courts are under the purview of the Supreme Court, we do it for circuit court clerks. And that helps us determine how many positions we need to do the work of the judicial branch. And so the district court workload study for the judges is one that we provided when these positions were authorized back in 2022, and we'd be happy to provide that information to you again.
Thank you, Ms. Butler, and very good points made, Senator. Thanks for that. If and when we take this up to the floor, that'll be really valuable. So thanks, Ms. Butler. We will go to anyone else who'd like to testify on this bill. Is there anyone else? Chief Perkins, great to see you this morning, as I said. Yeah.
That's pretty
Welcome.
good.
For the record, you know how this
Yeah,
works.
Mr. Chairman, Drew Perkins, Governor Gordon, Chief of Staff. I'm actually not testifying this morning as Chief of Staff. Just here I'm here as a private citizen and somebody who practiced law in the state of Wyoming for over 30 years, and until just last year, that's how I made my living. And so what I wanted to say was just particularly when I was in the Senate, and I've always, as a lawyer, I always have a peculiar interest in the judiciary for obvious reasons. And so I've spent a lot of time, and just as by way of example, and just maybe something to think about, and maybe something that might help as you go to the floor with some ideas about why these things are important. And so I've known and practiced in front of the three judges, particularly in Natrona County, for a long time. And even in Natrona County, where they had three judges, I think we're on the way to the fourth. And sitting down with those, I mean, you go into the courtroom to represent a client at a hearing, and you go over and you walk over to the side and you look, and all three judges' schedules for the day, their hearing schedules are laid out. And those judges come in and they start hearings right around 8 o'clock. And sometimes those hearings go right to 5 o'clock. I mean, just maybe with some time off for lunch. Now, that sounds, sure, that's a full work day. But I think the thing that a lot of people don't think about judges is when you're in a hearing all day, when you're working all day, when do you sit down and read the voluminous submissions that come in? When do you sit down and think about what's, and formulate and do this research and then go back and you have to research. It's not just you read that. A lot of times you have to get on and do your own research. You have to go back and look, maybe read the cases that have been cited to see if it really means what the lawyers say it means, because lawyers are advocating for specific positions. So we all know that you can shade things one way or another with the same set of facts. And so as you do that, I mean, that's one of the things that you have to think about. Not only is it delay, we often hear that justice delayed is justice denied, which is very true, but you need good decisions. And as you go through the efforts that you do to handle the high volume of stuff that you do, I'm sure that you feel at times that you wish you could give a lot more time to the decisions you have to make, and you're making very important decisions for the people of the state of Wyoming, whether it's about budgets or whether it's about other issues. And it's really important to make sure that judges have some time to think. They can't always be in the court on the gavel listening to people, so they have to sit down. And if you look, when I started as an attorney, the average case file was about this thick. Now I think the average case files, if anything is very hard, probably is multiple files, and it's probably this thick. Now you don't see that anymore because we're going to electronic filing, which probably, as we all know, digital technology increases the amount of paperwork, not decreases the amount of paperwork. And so it's just important to recognize that not only is it just about time, but it's about quality. And none of us can do it if we don't have enough time to think. We don't have enough time to actually do the job. The job isn't necessarily to be in hearing. The job is to make the best decisions they can with the facts and the law that they have before them. And so these things are really, really important to the people of the state of Wyoming. And district court judges, as you know, under our Constitution, they're pretty much that's the court of general jurisdiction. Yeah, and so it's everything from murders to domestic violence to they do the juvenile multidisciplinary teams. They do, so the juveniles are in there. They have all kinds of litigation, whether it's domestic violence, whether it's they do, and not only that, then these things have different priorities. So you may have your schedule, but here comes a new criminal case. Well, you have a right to speedy trial. So now those things start to weave their way in. You have people that come before you, they need a temporary restraining order or they need a preliminary injunction. You have to move those things in and put them ahead. And ultimately, not to mention the time that you may have to wake up in the middle of the night to make a decision about some kind of search warrant or other immediate relief that's needed, whether it's in the district court. Most of those are in the county courts, but those things all, I mean, being a judge is not even an 8 to 5 job. A lot of times it's pretty much a 24/7 job. And so it just, they're only human, but they need, the other thing and I'll just finish with this, is that one of the things that struck me as a lawyer when I came down to the legislature, particularly as you looked at the budget, is what happens in a district court. You have to remember, district court isn't a big thing with a lot of support. There are groups of 4 or 5 people. There's a judge, a judicial clerk, which usually is only out of college for somewhere 1 to 3 years.
You dropped your, sorry.
That's fine. Has only been out, a judicial clerk's only been out of law school for 1 to 3 years doing complex litigation. A court reporter and a judicial assistant and executive secretary, somebody help with clerical work. And they're handling everything from first degree murder to divorces to business cases to probates. It's a big job, and so we need to support them where we can. Thank you, Mr. Chairman.
Really appreciate it, Chief Perkins. Thanks for those words. And before you go, any questions, any thoughts for the former chairman of Judiciary and former senator and the chief? Thank you, Drew. Really appreciate it. Further testimony on this bill. We are on Senate File 53, the 6th Judicial District number of judges. Good morning.
Good morning, Mr. Chairman, members of the committee. Beth Lance, here on behalf of the Wyoming Trial Lawyers Association. I won't bore you with repetitive comments. Certainly, our membership would agree with everything that you've heard here this morning from Ms. Butler and Mr. Perkins. We certainly see this as an access to justice issue, has been stated. And our members know that the 6th Judicial District specifically is in need of this 4th judge, and that their dockets are reflecting that need, and that it is delaying civil, of course, primarily cases, which often include obviously family, custody, really important issues that unfortunately have to be placed on the back burner due to statutory requirements to hear timely criminal and juvenile cases. And so just stand in support of this bill and would ask for your aye vote.
Thanks, Ms. Lamb. Any questions, committee? Thank you very much. Appreciate any further testimony on Senate File 53 this morning. Anybody online, Lily, who wishes to testify? Once again, any other further testimony? Okay, we'll close public testimony. What's your pleasure on this bill, committee? Moved by Senator Cooper. Any amendments on the bill? Okay. Lily, would you please take roll on Senate File 53? Aye. Aye.
Aye.
Aye.
Aye. Well, committee, since I have a name there, I will take this into the breach, okay? And I know you'll be right behind me if the fight breaks out, right? Okay. All righty. We have another senator amongst us, and the next bill for our consideration is Senate File 92, Registered Sex Offender Employment Restrictions. And so that's the next bill we will take up. Want to welcome Senator Ellis to Judiciary this morning. Speaking of trial lawyers, it's good to see you.
Thank you. Thank you, Mr.
Tell us
Chairman.
about Senate File 92, Senator.
Yeah, thank you, Mr. Chairman. And I want to thank the chairman for allowing me to present first. I've got another bill that I'm co-sponsoring up in Senate Education. So I apologize if I'm looking at my phone. I'm trying to juggle a few things this morning.
You're good. Whatever we need to do.
Yeah, so Mr. Chairman, this bill was actually brought to me by a constituent. And the constituent raised a concern that she had about a former classmate of hers who committed some acts, was on the registered sex offender list, and she saw this person in the community. And this person, I think the concern is that they have a propensity of taking jobs where there still are a number of young people working. And so as she observed this, we did some research together. And just looking at, and I know this committee has done a lot of work, as evidenced by the next two bills upcoming. There's a lot of research about the potential recidivism of people that have committed certain sex acts, particularly those against minors. And so it's in that vein that we bring this bill to you. Some of the strongest predictors of sexual recidivism are factors related to the sexual criminality, such as a demonstrated sexual interest in children, a history of prior sexual offenses, the age of onset of sexual offending behavior, and having committed a variety of sexual offenses. And so I know this committee is familiar with a lot of the work that is out there by our federal agencies, such as the Bureau of Justice Statistics and the Office of Sex Offender Sentencing. So with that, in doing some research about what other states, if other states had looked into this issue, I did find that two of our sister states, Alabama and Wisconsin, actually have laws in the book that prohibit where sex offenders who have committed crimes against minors can be and work. You might recall, senators, about 10 years ago, the legislature during a budget session introduced a bill that's codified at 62320 that prohibits registered sex offenders from being on school district facilities. And that bill applies to things like school buses, but it also contains some exceptions if that sex offender gets permission from the principal, etc. That statute also creates a misdemeanor crime found in subsection C that any person who violates that provision is guilty of a misdemeanor, could be imprisoned for up to 6 months, a $750 fine, or both. So in looking at that legislation, I tried to put together some of these various concepts, and that's what you see before you in Senate File 19. It would create a new section 321 in that same area of the statute. And going on to page 2, that's the meat of the bill. Under subsection, or paragraph A, on page 2, it would say, beginning with Romanet 1, it would prohibit a registered sex offender who is of 18 years of age or older, who is registered on the list for a crime involving a minor. So not all sex offenders, only those who have committed crimes against a minor, for applying for and accepting or engaging in any paid or unpaid employment or volunteer position that requires the registered sex offender to interact primarily and directly with coworkers who are minors. So, Mr. Chairman, there certainly are some, real life examples. My daughter this summer, for example, she's now 16, but at the time was 15. She took her first job at a fast food restaurant. And when I would drop her off this summer and walk in and sometimes get myself a sandwich, just seeing all those young teenage faces, I was imagining how comfortable some of those parents might be if they weren't even aware that one of their colleagues that's interacting in close quarters with those young people, how they would feel if they knew that that person was a registered sex offender. So this would only apply, though, in those instances where there's a pretty strong concentration of minors, and that's why we use the word primarily and directly. Another example of the word directly that we're trying to get after is there's an arcade in town in Cheyenne that has a lot of children that occupy that place, but they also have a bar area. So if the registered sex offender is providing drinks on the bar side of the arcade, they're probably okay because minors are not allowed to be on that side of the building. But if they're actually working with kids on the other side of it, that's a prohibited position. Romanet 2 on page 2 says they also are prohibited from applying for and accepting or engaging in any employment or volunteer position that requires them to provide services primarily and directly to minors who are unaccompanied by parents or guardians. And so again, we're getting after the situation that I just mentioned. If you're in an arcade and kids are often dropped off and walking around freely. Another example would be we have a trampoline park in Cheyenne where a lot of parents just drop off kids with some money and the kids are left to roam free. Those would be unaccompanied minors. But it wouldn't apply, for example, if the sex offender was serving at a restaurant and primarily children that eat there are with their parents. So it's trying to build in a little bit of wiggle room, just acknowledging some of those real life concerns. Recognizing, though, that this is an imposition on people who have are on this list but have done their time and paid their debt to society, we wanted to make sure that there were some provisions included that provided some exceptions. So we'll begin that on page B, and this would require the registered offender, if they believe this section shouldn't apply to them, to obtain a court order to relieve them of this requirement. And so going on to page 3, you'll see the particulars of what the registered sex offender should put in their petition to the district court, beginning with Romanet 1, and then on to page 2, or excuse me, Romanet 2 on page 3. The petition should be served on the prosecuting attorney for the county, and it should include some information: a certified copy of the adjudication or their conviction, a list of each registering agency in each county and each jurisdiction where the registered offender is required to register. Going on to page 3, the registered offender's criminal record, and then a justification as to why the court should grant relief. And so concluding the requirement, the court should hold a hearing prior to the ruling on the petition, and then the court can grant relief if all of those requirements have been satisfied by clear and convincing evidence. Continuing on to bottom of page 4, paragraph C, any person who violates this provision is guilty of a misdemeanor, up to imprisonment of 6 months, a $750 fine, or both. Again, borrowing from that statute that already exists in Wyoming law that sex offenders cannot be on K through 12 grounds. Going on to page 5, the remainder of section 2 is really just a conforming amendment, nothing to really talk about. And then on to page 6, the enactment clause. And this is something, senators, I've really toiled over. If you look at the handouts that I provided you, I'm sure, as you mentioned, as I'm aware, you have been doing a lot of work on looking at our sex offender registry list. And so I provided a couple of graphs just so you can see the number of people that are on the list currently. Right now, there are about 2,500 registered sex offenders in Wyoming, the highest numbers being in places like Natrona County, Laramie County, Goshen County. And then I also added a chart that shows how many are added each year. So about 100 new sex offenders added to the registry each year, 115 or so. And the reason this is important is we have some ex post facto concerns. And you're the Judiciary Committee, so I'm sure you're aware of what that means. But essentially, governments are prohibited from criminalizing behavior that's already occurred. So my example would be if I shoplifted something and my fine was $100, I paid my fine. The legislature can't go back and say, actually want the fine to be $1,000, and then come back after me and say, we want another $900. That's an ex post facto law. So the argument would be here that these registered sex offenders are on the list, they've already paid their debt to society, and now we're providing further limitations on their rights. And so with that, that's where the effective, the effective clause you'll see in your bill says the act shall apply to employment and volunteer positions that begin on or after July 1st. So that would essentially grandfather in those people that have those jobs right now. It wouldn't require them to quit their job and seek new employment. If you wanted to take it a step further, and that's the amendment that you're going to see in front of you. If this were to be challenged, that would be something that a potential sex offender would raise, is this is an ex post facto punishment. You're further limiting where my employment might be. So I was really conflicted over which way to go on this. In looking at some case law, the Supreme Courts of various states have different kinds of tests. Wyoming does too. When the initial sex offender registry list became a thing even, and it was a case called Kammer, and the courts look at whether or not a legislative body is trying to be punitive or apply additional penalties, things that you normally think of as penalties, jail time or financial fines, or if the state is exercising kind of a regulatory interest. And so we've upheld our ability to have a sex offender registry list on that regulatory ground. I think the bill as written would survive a judicial challenge. I think that. I don't know that. So if you wanted to take it a step further and really make this clean and maybe avoid that altogether, the proposed amendment that you would see in front of you would say this only applies to those individuals who are added to the registered sex offender list for crimes against minors starting July 1st, 2024. And so that would essentially grandfather in everybody who's on these charts right now, but it would be very much forward looking. And so as I worked on this bill, I think very much trust the wisdom and judgment of my colleagues. I just didn't get a chance to visit with everybody before the session started. So I thought it would be appropriate to present this concept to my colleagues in the form of an amendment, as you'll see today. So if that's something you're willing to take up, I think it might strengthen the bill, make it a little fairer to those people on the list. But the con of that is, the purpose of this bill, it really is to try and protect kids from recidivistic behavior, and just knowing about the number of sex crimes that exist out there against children. I think that's on the forefront of my mind, certainly not to be punitive to these individuals. So with that, Mr. Chairman, I'm happy to answer any questions.
Well done, Senator. Appreciate it. Any questions of the sponsor of the bill? Senator Case.
Thank you, Mr. Chairman. I think I would have several, maybe if I could just kind of link them together. We have this list of the registry, and it talks about the G lifetime, H lifetime, and J lifetime. Could you explain what that is?
Yeah, Mr. Chairman, let me pull up my notes because I knew this would be a question, and I was hoping I wouldn't get it because I assumed that you all had been working on these and were familiar with what the G, H, and whatnot are. But if you look
Senator,
under,
I forgot what I had for breakfast. So
and I haven't had enough coffee. So if you look at Wyoming Statute 719-301 at sequitur, that's the sex offender registration. There are a number of violations in there that qualify, that are categorized differently. So if you look at the G lifetime, this talks about an offender who has committed 62316A Romanet 1 through 4. And so I went through and I documented all of these, and there are some qualifying things in here. You've got your criminal code in Title VI. This is found in Title VII. So some of these are the elements of the crime coupled with some exceptions that are contained in Title VII. I hope that makes sense. And I can give you my notes later on. But so, for example, this would include sexual abuse of a minor in the 3rd degree, sexual exploitation of a child for any purpose if he knowingly possesses child pornography. There are exceptions in that statute for peace officers, physicians, et cetera. And then felony voyeurism. And so you'll see, for example, under the G lifetime, that's found under 64304B, felony voyeurism if the victim is a minor. Going on to the H lifetime, the offender, it's got a list, and so it is sexual assault in the 3rd degree if the victim was at least 14 years of age, sexual abuse of minor in the 1st degree, sexual abuse of the minor in the 2nd degree, sexual abuse of a minor in the 2nd degree if the offender is 18 years or older, engages in sexual contact with a victim was 13 to 15 years of age, and the actor occupies a position of authority related to them. It would also cover sexual abuse of a minor in the 4th degree, soliciting to engage in illicit sexual relations, soliciting an act of prostitution if the person solicited is a minor, promoting prostitution, promoting obscenity, and that includes producing or reproducing obscene material with the intent to disseminate if the victim is a minor. The J lifetime includes kidnapping if the victim was a minor, sexual assault in the 1st degree if the victim was under 14 years of age, sexual assault in the 2nd degree if the victim was less than 13 years of age, sexual assault in the 3rd degree if the victim was less than 13 years of age, sexual abuse of minor in the 1st degree, sexual abuse of the minor in the 2nd degree, and incest. And so, like I said, it's a little hard to quantify some of this because they reference crimes in 6, but then they're modified in the 7.
So generally speaking, these are just not so serious, medium serious, and high-end serious.
Mr. Chairman, so I think one criticism of this, and that I've heard is, and this is something I think that your committee is grappling with, is sometimes you'll hear people who say, well, I'm on the registry, but I made a really stupid mistake when I was young. And then others that, when you hear the circumstance of the crime, you really get the chills because it's creepy and it's not right. I think that's a broader question about how we fix those lists rather than what this is seeking to do. I think if we, were to address some of those concerns, it would definitely provide some strength for, the concept of this bill. I'm sympathetic to it, but this isn't the vehicle for me to fix that.
Okay, thanks for that. Back to you, Senator Case.
And so, Mr. Chairman, this bill applies to all of those, right? And really anyone that's on the sex offender registry. Is there any people that are not caught up in this bill that have been convicted of being a sex offender?
Mr. Chairman, this would only apply to crimes involving minors.
involving minors.
And there's a definition, I don't have that at my fingertips this morning, but it's a term of art, and it includes just that list, the HG K list.
Mr. Chairman, and that would include statutory rape. And it would include statutory rape where, by definition, there would be more than 4 years difference between the perpetrator and the victim. Would that be true?
Mr. Chairman, I don't want to misspeak, but I think that's true. I think in a number of our statutes, we do contemplate what happens if you have, a 18-year-old in a relationship with a 16-year-old or things like that. That's all in Title VI right now. And so I didn't touch any of that. And it's a little complicated for me to just say it on the fly because I don't practice in this area. I can't just rattle it off. But if we wanted to look at like 62316, being 17 years of age or older, and the victim is in between the ages of 13 or 15. I mean, it's got all of that language existing. So I didn't tinker with any of that.
And it may not surprise you, just to interject real quickly, Senator, and then back to you, that in our work with a couple of other bills this past interim, it has come to our attention that there may be an inconsistency or two in these long lists of things. So it's very likely that we'll continue work on this going forward for however long. Senator Case, go ahead.
Yeah, Mr. Chairman, I guess I'm not sure that we know how many people are in these categories. And the statutory rape issue is bothersome to me a bit, and because there are lots of times it's usually male with a younger female, doesn't have to be, but and usually the person can be at a the perpetrator could be at a very relatively young age. And I'll just say relatively young, maybe that's less than 25. I don't know, in your long world. Maybe less than 20. And then you have this requirement would apply as long as they're on the registry, I assume. Is that correct?
Mr. Chairman, prospectively, yes. And all I can do is point you to 62316.
Mm-hmm.
So that's sexual abuse of a minor in the third degree. So if you have someone who's at least 17 years of age or older, they engage in sexual contact with someone who's between the ages of 13 and 15, and the victim is at least 4 years younger than the actor. So I think in looking at that, if they're 17, then it gets down to that 13 level. And that to me is inappropriate. That's, a high school senior with a junior high person. I think that's to me not right.
I'm not saying that it's appropriate.
No, but so I'm just saying, Mr. Chairman, I'm sympathetic to your concern, but I just didn't want to try and address all of the concerns you might have. It's outside of what I was getting after. And I get the connection, but I don't know that I'm going to give you an answer that's satisfactory.
I don't even know I've got my question out yet.
Yeah.
Oh, I'm sorry, Mr. Chairman.
So thank you. So, Mr. Chairman, in those situations, there's potentially a lifetime of being on the registry. I think in some cases you can petition to get off. We're talking about expanding the situations where you can petition to get off. So those registry that would have consequences. Your name is published, anybody can look it up, an employer could look it up. But yet this is kind of another level. And in my business, I employ minors. I'm working with a man who is now nearly 30, who worked for me about a decade ago. And at the time he applied for his employment, he told me he was a registered sex offender, and he told me the nature of his crime. And I employ minors, Mr. Chairman. I employ minors. And I hired that young man. He's one of the best people I ever hired. He's very, exemplary citizen, and I'm very proud of him. And I'm trying to think if I can recall, and this is getting to my question, the reoffenses of many of these risk is extremely low. Some, and I don't know exactly how to assess it, but I know that as an employer, I looked off the table. I knew the man's family. I knew the situation. He explained it totally. And to have me be restricted from hiring someone of that caliber is a hardship on my business. And I think it has a low return to society. What I'm trying to get at is if you look at these numbers, and I'd like Senator Ellis to tell us what actual statistics we have, how many crimes does she think that this bill would prevent as we go forward? And I can understand an answer that something like even one would be worth it. These are people that otherwise have paid their debt to society. They're on a registry for their lifetime, or in some cases they can get out with a difficult process to petition the court. And we're adding to it. To me, it's much akin to marking someone like with a, something on their forehead or sewn into their clothing. And I'm really kind of offended. And I just want to know what is the data about what this is going to prevent?
Senator Ellis.
Thank you, Mr. Chairman. So we've got a lot of numbers, and I'll try and do my best to answer the good senator's question. The numbers I've looked at are all taken from our federal agencies. I don't think that this data exists for the state of Wyoming specifically, unless this committee would know better than me. And I want to be clear. I know you're doing a lot of work on sex offender registry lists. But the data I'm looking at is released sex offenders were more than 3 times as likely as other released prisoners to be arrested for rape or sexual assault. The percentage that I have been looking at is 7.7% versus 2.3%. Looking at the Office of, or the Bureau of Justice Statistics, they did a 9-year follow-up from 2005 to 14 on recidivism of sex offenders released from state prisons. The difficulty in some of these is just given the large number, depending on the study you're looking at, parsing out people who are on the list versus those who are on there because of just sex crimes, but this is the data they had. Of the released sex offenders who committed another sex crime, 40% perpetrated the new offense within 1 year from their prison discharge, and the majority of children, and this was talking about child molesters, the children they molested after leaving prisons, they were aged 13 years or younger. 1 in 4 girls and 1 in 6 boys, according to the National Sexual Violence Resource Center, may be sexually or will be sexually abused before they turn 18 years or older. And then there's some other data about child pornography. According to one study that I found, 12% of child pornography offenders had an official arrest or conviction record of contact sexual behavior. 55% disclosed through self-reporting conducted through treatment programs about their offenses. But I've also seen other statistics, and I don't have those in front of me, that there's always a qualifier that sex offenses in general are generally underreported. So what does that mean? When I look at the numbers of people on the registry list right now, we have about 100 people that enter the registry every year, and that includes, I think, all offenses. I don't know that there's a breakout, but then you can see the numbers in this other chart that I provided you. In my community, for example, in Cheyenne, there are about 450 people on the registry, and you'll see that about 100 of them are from the G lifetime category, 146 the H lifetime category, and the J lifetime category of 200. So I think the senator's points are well taken. I'm not trying to be offensive. I'm expressing a concern I heard from a constituent and people in my community about the interaction of people that have committed crimes against minors involved that are sexual in nature, of having an opportunity to prey on those minors and be repeat offenders. And so, really tried to thread the needle on making sure that some due process protections are provided by making, if an offender is worried about it, they can take it to a court. But that's where the concern is, and I think it's a fair concern. And I understand the good senator's argument.
So Senator, I think that's really the rub, isn't it? I mean, that's really where the concerns expressed by the senator from Fremont County It really comes down to whether or not we can be assured in this bill that we're not being so onerous that we're going to severely cripple some of our small businesses out there. Are you comfortable as an attorney? Do we have the language in here that's going to protect so many of our felons? For example, many of these offenders are felons now. Not only do they have to register, but they're felons, and they can't work in a bank. They can't. There's so many places that they cannot work. A lot of them, frankly, do work in kitchens and food preparing type institutions. A lot of them work in our tourism industries because that's where they can work. And so is that, I know you probably addressed that concern. Have we done it adequately in this bill to where we're not going to just trample over the top of the local Perkins, for example?
Sure.
We've got a cook in the back and we've got some young people serving out in the front. Talk to me about that. Okay, please.
Yeah, thank you, Mr. Chairman. I think the key language that we included in this bill that says is on page 2, line 9, that requires the offender to interact primarily and directly with coworkers who are minors. Interact primarily. That's as close as the language I could find to get there. So if you have a situation where in your kitchen staff really are in the back and your other, servers are out in front, if you look at the time they spend together, and the registered sex offender could take their petition to court, say this to the judge and say, I don't think I'm violating this. I know it's not a perfect solution, but that's the idea behind it, is to try and provide some protection there.
Mr. Chairman,
Go ahead, Senator Case.
I think that's pretty unrealistic about a work environment in a business, like a restaurant. It just doesn't work that way. And that might be, it just doesn't work that way. And it would be tough on the employer to say, all right, everybody, Joe back there in the kitchen, he's a registered sex offender, so all you servers stay out here. Nobody gets to come in the kitchen. And Joe, keep your butt in the kitchen. I could try to run my place like that, and that's a little bit hard to do.
So go ahead.
Mr.
You're
Chairman,
welcome to
I wanna-
comment on that, Senator Ellis, and then I want to get to other questions on the committee.
Yeah, so this thing I'd offer in response to that comment was I did reach out to the organization in Wyoming that represents restaurants and hospitality organizations. Other states have tackled it by putting the burden on the employer, and we stayed away from that as much as we could to not imply or have any liability on the employer. So you'll see that this is a duty and obligation of the person that's on the offender list.
Thank you.
And
So-
would you
so
say
go ahead,
again,
Senator
Mr.
Case.
Chairman, the states that have done this? There was quite a list.
I believe Senator Ellis, you indicated Alabama and Wisconsin.
That's correct, Mr. Chairman.
Have passed this legislation to prohibit. So committee, let's take advantage of the good senator with questions we might have, and then we'll move on to some other testimony. We've got a couple of bills after this, so questions? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. Yeah, the question I think was already asked about the primarily. I had a little just concern with that language, but I think maybe I've gotten past that. But the question I had is really on the amendment. I just wondered if we really need it with section 3, or do you think the amendment just tightens that up? That I don't know what you think about that.
Go ahead, Senator.
Thank you, Mr. Chairman. So there are two ex post facto concerns. One would be if you said you can't have these employment positions right now, well, what if I already have that job today? So what the bill contains is a carve out that says you're grandfathered in if you have that job today where you're interacting with minors primarily in the workplace or providing services primarily to minors. The other one has to do with, so if we left it as it is, then once that person left that job and then sought new employment, then this prohibition would apply. What the amendment would do would say, no, if you're on the list right now, you're grandfathered in forever. These prohibitions don't apply to you. It only applies to new offenders on the list after July 1st of 2024. So it narrows that. So it wouldn't apply to anyone that's on this list right now. it would not apply to them. It would only be forward-looking. Presumably, if we have about 115 offenders on the list every year, it would apply to them. And then it would build the list prospectively like that, if the committee were to adopt that amendment.
Thanks for the clarification.
Okay, further questions?
Appreciate it.
Okay, Senator Ellis, I'm going to go to others who may want to testify on this bill, and I'm going to remind that every committee in the session at this time has lots of bills to consider and lots of work to do. So let's keep going on this one. Anyone else like to testify on this bill? Any other testimony on Senate File 92? Agency, organization, and then we'll go to the public. Okay. Good morning, welcome.
Good morning. My name is Kara Chambers. I'm with the Wyoming Attorney General's office. As you're aware, our office reviews all of your legislation. I've been in discussion with DCI, with the Criminal Justice Information Unit, who oversees the registry, and in consultation with attorneys in our criminal division. There are other states who have this law, and I apologize. I was across the hall with your colleagues, so I hope I'm not reiterating anything that's
Which,
the good
by the
Senator
way,
Ellis.
what kind of leadership would put both the judiciary committees meeting at the very same time? Anyway, sorry, I vented there for a minute. Go ahead.
Chairman, that has
Please
occurred to
continue.
me as well. At any rate, we are researching. We're not aware of any current constitutional challenges in the other states, but we are continuing to research. Of course, poor Kelsey Singleton had about 24 hours to try to get this prepared. I don't know if there was any discussion about, we were primarily looking at page 2, line 9, and line 14 and 15, where we talk about interact primarily and directly with coworkers who are minors and provide services primarily and directly to minors. And so we were wondering if there might be some language just defining that or describing that, or what are we talking about? And so that was just one thought that we had, that we weren't really sure how to interpret that. And so I probably just came up here and gave you problems, so I'll be quiet now.
Okay, any questions in the chamber? Thank you very much. I really appreciate you being here.
Thank you.
We have more work coming forward, so we might hear from you again. Any other testimony? Anybody else like to come forward on this bill? Welcome.
Mr. Chairman, my name is Bruce Berkland. I'm represent the Wyoming Youth Service Association. So our members have crisis shelters, group homes, residential treatment centers. I'm speaking today more as having been director of Red Top Meadows Treatment Center for 40 years or so, and as a therapist there. In a number, Red Top was one of the few programs in the state to work with juvenile sexual offenders. And the experience we had there, those young people that had committed that offense were young people that had been isolated and socially isolated from their peers, had little involvement. They had done very well in the program. Over the years, we had, in terms of if one of those juveniles reoffended again at a later date, I would get a notice for records. And probably out of the 200 kids we saw in that category, I think I got requests for records on 2. So I think, for the youth we were seeing, I can only speak to those people in particular and wouldn't apply to everybody. But I also completely understand what they've done is a bad thing. That's why they're in treatment. That's why they're working with us. I understand the need for the safety for the public. In some ways, I felt our concern was that having these youth on the registry at all only increased their isolation later and increased their likelihood of offending because they weren't involved in a normal way with their peers and having the social activity and involvement that they needed, and just continued to go back to where they were. With that, I would think, I would only speak, I might suggest that this bill just be clear that it maybe would accept, as an exception would be those people that committed the offense as a juvenile, and that they went through juvenile court and were adjudicated as opposed to convicted in adult court. There is that choice for when a young person commits an offense that the county attorney can, if it's particularly egregious offense, that they move to adult court. And so those youth that are at greater risk of continuing offense or their offense is particularly egregious can be in adult court. And I'm not saying that they should be exempted, but those other youths perhaps could. You could also say that the youth in particular has successfully completed a treatment program, which all records on that show the recidivism rate as being very, very low for those youth. And with that, I will stand for questions.
Questions? Mr. Bertrand? Really appreciate you being here. Thank you. Good thoughts. Anybody else wish to testify? Okay, anyone online? Okay, we're gonna close public testimony on this bill. Committee, what's your pleasure? Senator Cooper moved the bill. Discussion.
Mr. Chairman,
Senator Case.
I'm not sure that I'm going to be able to get there on this bill, but it would be a better bill if there were qualifications on who this applied to. People have long lives and they do dumb things when they're young. And puberty and sexual attraction, it's a mind-bending, powerful thing for, and so I would hate perhaps to mark our youthful offenders. And I think the last suggestion was probably a decent suggestion. I had thought about going down another road that didn't necessarily catch youth, but also dealt with the passage of time as people reflect on their world. And so I was going to propose, and I might still do so, but if you want me to do a dry run without a motion first, I'm happy to make a motion.
I would be interested in where you think you might go with that motion.
Okay.
So
if you look under A on page 2, it has an exception. Exceptions provided in subsection B. I was thinking of adding another exception, and the exception would be that the requirements of subsection A shall not apply if the crime was more, or it could be the crime involving the minor, was more than 10 years ago, and the perpetrator has not been convicted of any other crime or misdemeanor. So that's one way, and that could be a new section B, so the existing section B becomes C, and then the requirements of.
Committee, I
That's
think
an
I would
idea.
like to have that as a motion. What do you?
Well, that's a possibility. The other possibility is to deal with if they were youthful offenders at the time they did it. But the 10 years anybody that was a youth would no longer be a youth after 10 years. That would catch them, but it would catch more people. It would catch people that 10 years have passed without any kind of reoffense. So I kind of prefer mine, and I would make it as a formal motion, but I wanted to throw it out for the committee to think about.
I was just going to add, Senator, I appreciate where you're going, and I like that, and I like it as a motion, but I also like what our testimony provided to us just a few minutes ago regarding juvenile court, regarding certified treatment program. That's compelling to me as well, and maybe there's a B and a C. But I don't know how to meld those together on the fly here quite as well as I
think, Mr. Chairman,
Go ahead,
do
Senator.
we want to limit this exception just to perpetrators that were juveniles? Or do we want to broaden it and allow for the passage of time with a clean record. So I'm inclined to do both. And I think that 10 years actually does both, because it does catch all the youthful offenders, I think. You have to be pretty darn young, and I doubt if that would ever happen.
So committee, here, I'm just going to say where I'm at. I really appreciate the intent of the bill. I think that these two thoughts that we've just shared, we haven't put it in motion form yet, but I think that would help me to get there with this. I'd be interested in hearing from other committee members how you feel, or what do you, Senator Cooper.
Thank you, Mr. Chairman. I think it's going to have to be both. You know, if the offender was an 18-year-old when it happened, he's no longer in the juvenile system, but he's still in that category, even though he's not longer within the juvenile system. So I think maybe the 10-year thing would help that out, but I think we're going to have to probably do both in order to really cover this.
Okay. Well, Senator Case, let's, would you be willing to take a stab at that motion?
Okay, I'll try to
I'd love
blend
to
it.
have the juvenile court piece folded in with your thought, but.
I'm going to try to do it.
Okay.
Mr. Chairman, so the gist of the motion would be on page 2, line 1, and it's going to say, except as provided in subsection, it currently says, except as provided in subsection B. It's going to now say, except as provided in subsections, plural, B, C, and D, no person, blah, 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 blah. And then we would add on line 17, we're going to add a new section C and a new section B and a new section C. And then we're going to, on line 18, we'll take the existing section B and it's going to be numbered as D as in David. So the new section B would say the requirements of subsection A shall not apply if the crime involving a juvenile happened more than 10 years ago, or 10 years prior, I guess would be better words, and the perpetrator has not been convicted of any other crime or misdemeanor. And that's any other crime or misdemeanor. It's not just crimes involving juveniles. And then the next one would be the new section C, and I'm flying blind here, but the requirements of subsection A shall not apply if the perpetrator was a juvenile at the time of their conviction and the adjudication occurred in juvenile court. Is that necessary? Or was adjudicated as a juvenile at the time of their conviction? I'll sure try. Thank you, Mr. Chairman. The requirements of subsection A shall not apply if the perpetrator was adjudicated in juvenile court at the time, period. And completed court requirements for sentencing. That's poor language, but leeway given, please, Mr. Chairman.
I like it. Let's set the motion for just a moment. I want to give the sponsor of the bill an opportunity to come forward. Senator Ellis, talk to us about where we are with this amendment.
Thank you, Mr. Chairman. I like both ideas. My goal isn't to get after people who made bad mistakes. I think I have concerns like you do about the registered sex offender list, because you do meet people who say, I'm on the list and here's my dumb story. And you listen to it and you're like, wow, I get that. So do we need to work on the list as entirely as a state? Sure. But there are legitimate people who prey on children and they're creepy and it's not right. And so that's what this is getting after, is trying to prevent those individuals who have real needs, who need real treatment, who aren't getting it from having opportunities to repeat again. So I like the amendments, and I think, to Senator Case's point, maybe just allowing staff to, because I think they use the word minor instead of juvenile, that kind of stuff.
All that stuff, yeah.
Yeah, but I think you're headed in the right direction, and just would ask you to not forget a discussion about the other proposed amendment I brought to you.
You can tell the committee wants to get there, and so thank you for that, Senator, appreciate it. Okay, so committee, we have a motion on the floor by Senator Case, and I think when it gets upstairs, it can be doctored a little bit.
Absolutely.
That's what our professionals do for us. But Lily, Pierre, do you guys have that over there?
Mr. Chairman, we have it, but if it would be helpful if we could bring the language to either you or to Senator Case before we give it to the attorneys to make sure it's what you want.
Absolutely. And Mr. Chairman, I would be comfortable sharing it with everybody else too. Just
Absolutely. I think if you don't mind, Lily, if you would provide that to Senator Case, myself, Senator Ellis, that way we can be assured that we're honing in on what we want to get accomplished here, okay? So,
and Mr. Chairman,
go ahead.
you don't have to repeat my words. You can rephrase it. You certainly both could do a better job.
Thank you for that, Senator. Appreciate it. Thank you, Lily. Okay, everyone understand the motion? All in favor of Senator Case's motion, say aye.
Aye.
Any opposed, no. That motion has passed. Does anyone have, go ahead, Senator Schuler.
Thank you, Mr. Chairman. I would go ahead and offer, since I got some clarification on Senator Ellis's amendment, after, let's see, it's page 5, after line 2, insert, just, as it is, the amendment on page 6, on page 5.
Okay, that motion, I'm just looking over at Lily and Pierre. You have that, hopefully, provided by the sponsor of the bill. Questions, discussion? All in favor of Senator Schuler's motion, say aye.
Aye.
Any opposed, no. That motion carries. We're back on the bill. Anything further on Senate File 53? 92, my fault. Senate File 92. Pierre.
Was the amendment from Senator Schuler just for page 5 or for all amendments on the proposed amendment from Senator Ellis?
That was just the tagline, and I think the intention was the entire amendment that was provided. Yeah. Okay. Lily, would you please take roll on Senate File 92?
No.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye. Thank you for being here, Senator Ellis. Good luck upstairs. We're right behind you if a fight breaks out. Good luck elsewhere this morning. We'll see you later. Next bill for our consideration is Senate File 31, Sex Offender Registration Promoting Obscenity. Committee, you'll remember that this was an interim topic bill. It was a language that was provided to us, I believe, by the Attorney General, if I remember correctly. We worked this bill, so let's dive in. Is there anyone who wants to come forward and give us any thoughts on Senate File 31? Is there anyone who would like to speak to Senate File 31? Okay, so committee, I'll close public testimony on Senate File 31, and let's work this bill. We've been through it before. So, discussion.
Mr. Chairman, help me with what this bill accomplishes. I'm not trying to be hostile, I swear. So this deals with someone that takes obscene material and gives it to a minor? Is that what this is about?
I believe that's my recollection.
Okay.
And I thought that we actually talked about this. What prompted some of this discussion was the AI piece.
Okay.
We talked a little bit about AI, you'll remember. And I'm assuming that this may cover some of that.
It's the most long sentence I think I've seen, and
Yeah,
it's like, whoa.
it's almost like an attorney made this sentence, right?
Could we
I
get
say that
Ms.
lovingly.
Chambers to maybe help us if she could? I'd appreciate it.
Yeah, Ms. Chambers, please. No, please come forward. That'd be great.
Chairman Carrot Chambers, Attorney General's Office, just to refresh the committee's memory, this was sprung out of the testimony from the young woman from Maine, whose offender is now living in Wyoming. He was a lifetime registrant in the state of Wyoming because they had obscenity covered under their laws, but we don't. And so now he's moved here and doesn't have to register as a sex offender, but he had groomed her using obscene photos.
Ms. Chairman,
Go ahead,
she
Senator.
was a minor, right, at the time?
Yes, sir. I believe it was like a youth. I
Yeah,
think they were-
it was a church youth group or something. It
Yes,
was,
sir.
and then, does it matter what the obscenity depicts? It's just any kind of obscene material, right?
Go ahead.
Chairman Landon, Senator Case, obscenity is defined elsewhere in statute.
Yeah, so it's not child pornography that he's using. It doesn't matter. You're saying it doesn't matter, and that's fine. Got it.
Yeah, thanks, Ms. Chambers, for that reminder, what prompted that. And I think that does cover, the intention was to cover people who might come here from somewhere else and find themselves not having to live up to certain things that they were required to do elsewhere. Okay. Senator Schuler.
I think just, what I'm hearing in society with, the increased number of apps that are out there, that we're seeing an increase in this just because, not necessarily sex offenders, but, bad actors are convincing these young gals, particularly more than the guys, to send naked pictures, and then they send naked pictures back, and then all of a sudden, then it's a scam to try to get money. And I think we're seeing an increase in that kind of stuff. So I really think this is a good catch in our statutes.
Ms. Chambers, I'm sure you agree and probably hear and run into in the Judiciary branch all the time nowadays. We've got a lot of this kind of stuff going on, a lot of images being thrown around, and everybody's carrying around 6 or 8 different streaming items and whatever. Really appreciate your help on it. Thank you. So, committee, further discussion? I think whoever might be willing to take this on the floor, if it does pass today, I'm sure that Mr. Fuller can help us with information that was provided at the interim meeting when we took this up. And we could do, just a further refresh on that. But I think the intention of the bill is spot on. So anyway, are we ready for a motion on the bill? Okay, Senator Schuler has moved it. We can continue any discussion.
So,
Any amendments?
Mr. Chairman, I still think this thing reads awkwardly, but there's this list of things that if it were committed that include an offense in another jurisdiction, on page 2, lines 8 and 9, after the list, it says an offense in another jurisdiction containing the same or similar elements or arising out of same or similar facts. So that would be the person from another state. And now it was suggested in the testimony that if we add these words on lines 6 and 7, that means someone that moves in from another state that had groomed someone using pornography now would have to register in Wyoming, is what I understood. But this also does this create a new crime in Wyoming of grooming someone with pornography? I assume that's not true. But are we doing this? I'm going to look back to Ms. Chambers, and I should have asked earlier, and I apologize. But are we doing this because we have this loophole about not being a similar crime in other states? but it would be a crime in Wyoming and it's not part of the list? Is that what's happening?
Ms. Chambers?
Chairman, Senator Case, yes, so the language you were just referencing is existing law and talks about how if they register in another state for a crime that's substantially similar to a crime in our state, that they would also have to, so it's like reciprocal registration, if that makes sense. But the loophole in this particular is that we did not have this obscene material. So just to clarify, what was sent in her case was pictures of him. So it wasn't child pornography. He was
Okay.
sending pictures of himself. So it's to add obscene material as a registerable offense. Now, grooming through, child pornography is obviously illegal already. That's a very broad definition, whether it's computer generated or not, already a crime in Wyoming. Sextortion, also already a crime. So this was just the fact that he was sending nude pictures of himself, so this obscene material, and that was not a registrable offense in our state. So we're adding that just little line, and then to the already existing language that says, because he was convicted elsewhere, he'd have to register here.
Mr. Chairman?
Go ahead, Senator Case.
It's better to do it here than on the floor and try to figure this out.
Sure.
So in Wyoming right now, if someone sent nude pictures of themselves to a minor, and they printed them off and it looked like, well, how is that any different than pornography if you supplied pornography to a minor? Isn't it pornography? You know what I'm trying to say?
Yeah, why is there a loophole?
Yeah, well, I don't get the loophole.
Why was he allowed not to register?
Chairman Landon, Senator Case, I believe it was because so in our sex offender registry, we have listed offenses, and it just wasn't one of them in there. While it might have, by the behavior itself, might have been a crime in some other extent, because he was convicted elsewhere. Does that make, maybe I'm confusing the issue. It was a loophole, just plain and simple, because it wasn't listed as one of the registrable offenses. He didn't have to register because of the way, and because we didn't have obscenity as a registrable offense.
And obscenity is a little bit different than pornography, I'm sure.
Yes, it
Probably.
has a broader term.
Because of
My head's exploding.
definitions.
So in Wyoming right now, is it a crime to provide someone to provide a minor, say an adult to provide a minor with obscene material or pornography, or pornography? Is it a crime?
Ms. Chambers.
Chairman, I'm pretty sure. I believe, yes, I believe, you'll have to forgive me because I don't practice in those statutes all the time,
Okay,
but I'm pretty sure it is, but they could be convicted of it, but not be required to register as a sex offender, is
okay.
what I believe we're trying to close the loophole on. Because there's a lot of crimes that you don't have to register for. Not a
Okay.
lot, that's a hyperbole.
Let's drill down on this.
Yeah.
So they're convicted in Wyoming of providing obscene material or pornography to a minor.
Yeah.
But they don't have to register
Correct.
in Wyoming. But this means that will now the Wyoming people have to register if they're convicted of this?
Chairman.
And that also catches the people from the other state because of the reciprocity?
Yes, and it was an early morning, as we aforementioned. The actual citation to the crime is already there. So yes, that is
It's 643.
why Lily didn't phone a friend for me and be like, Kara, the law's right there. So 643, I'm going to blame Lily. No, 643-302A, Roman numeral 3 is the crime that already exists, that if you provide obscene material knowingly to a minor, that is the crime. So you are correct. We are adding that to the list of registrable offenses. And yes, it would apply to anyone convicted of that, whether they were convicted in Wyoming or other states.
Okay.
So let's look at that. When I was a little kid, I used to go down to the
Oh, Lord.
garage where they worked on the mechanics were there. I loved hanging out with them.
I'm not sure.
They had girly
The garage. Senator
calendars and Playboy centerfolds and stuff, It's a big deal to a little guy down there. Is that what we're talking about?
Chairman,
I'm sorry, I just can't, these things drive me crazy.
Senator Case,
So-
I don't think so. But
that's where the
Go ahead.
knowingly.
Yeah.
That was inadvertent, if you will. I don't want to go down that rabbit hole.
I think we're gonna move on. I think we've drilled enough, and we can do a little homework up above. If we don't get enough homework done and we're not comfortable enough and don't present it well enough, then maybe it isn't voted through. But I'm inclined to send it up to the Senate. So I would entertain, I think we've got a motion by Senator Schuler already. I'm inclined to go to a vote. So Lily, would you take roll on Senate File 31?
Senator Case.
64302 Romanet 3 says knowingly disseminates obscene material. I'm going to vote no for now.
Senator Cooper.
I've got some real concerns with it, but the fact that it is a committee bill and we worked it pretty hard in the interim, I'm going to vote yes for now.
Senator Furphy.
I'll vote yes.
Senator Schuler.
I'm gonna say aye
Aye.
as well. I'm sorry, Senator
That's
Schuler
all right.
first.
That's all right.
She's an aye, and then I will be an aye. But I think I'm gonna, would someone like to carry this, and I will do some homework, but I honestly would be fine with whoever, but would one of you like to carry it? Senator Furphy, why don't you try it? And let's just refresh our memories, get with Mr. Fuller and find out exactly what this does, and we can maybe even provide that to the body. But, okay, so Senate File 31 has passed the committee and will go up to the Senate for consideration. The final bill for consideration, I would like to get through it if we can this morning, committee, because we have a lot of bills in the hopper for next week. So let's take up Senate File 34. This is another bill that was worked during the interim. Ms. Chambers, would you be willing to come up and visit with us on this bill as well? Please, that would be helpful. Sex offender registration, registrable offenses. The single line in the bill is on page 3.
Yes.
Can you hone in on what that language means for me, Ms. Chambers? Can you remind me?
Chairman Landon, I will do my best. As you'll recall, Kelsey Singleton did the heavy lifting during the interim because she's the attorney who does this all the time. I believe we're just closing yet another loophole that somehow this language wasn't carried over into this particular level of registration, if I recall. And again, I'll be the first one to admit that there's sex offender registry is so nuanced, but I believe we're just, again, this is an existing, we're not creating a statute. We are just including a statute that was omitted from the sex offender registration. That was my understanding of what we were doing in the interim on this particular bill.
I could try to help a little bit too.
Okay, Senator Case, go ahead.
Well, Mr. Chairman, I think this was a discussion of when you could petition to get off the registry and whether if it was a lifetime or whether it was, there are some offenses that after 10 years you can petition the court to get off of. And both of these additions are in areas where existing law is it's a lifetime ban. And we're saying, well, if when the crime happened, there was an age difference of more than 8 years, yes, it's a lifetime ban. It's a person that really should know better. But we're cutting it off at 8 years and saying if you're 8 years older than the victim and you meet the crime of statutory rape is what this works out to be, then if you're 8 years or less, I think is the way it works, then after 10 years, you can petition a court to get off the registry think I have that right?
Chairman Lynn, Senator Case, thank you. And you jogged my memory because this was from the gentleman's testimony where
Yes.
he felt that because of the age of his victim, he was in a more onerous registration. What am I trying to say? Category.
The lifetime,
Yes,
right?
he was under the lifetime in that people who had committed more egregious offenses were not. So yes, it was an equity argument, I guess. But you are correct. Absolutely. I should stop talking.
And you remember, Ms.
Paraphrase.
Chambers, subsequent to that, the gentleman who I believe wants to testify this morning as well.
Yes.
Has indicated that there are other discrepancies in these statutes. And I think the committee is aware of that. Unfortunately, in a budget session, in a situation like we're in now, we probably aren't going to be able to fix all that's wrong in these statutes that we've alluded to this morning. But that's exactly right. And I appreciate Senator Case, you catching us up to speed on that. It certainly makes sense. So thanks. And you too, Ms. Chambers. Anything else on the bill? Kara, there is language on page 4.
Chairman, I believe that's just
refresh ourselves a
conforming.
little bit.
Mhm. Chairman, I believe that was just to make sure that we've captured that in all places in the statute.
Okay.
And these sections, Mr. Chairman, the H section on page 3 and the J section on page 4, they kind of refer to this list that was provided by Senator Ellis
Ellis,
before
that's right.
with the G, H, and J. So these carve out exceptions to the lifetime registration under H and J.
And those are long lists and heavy statutes. Just like the language in these last two bills. Okay, thank you. All right, let's go to any other testimony on Senate File 34. Does anyone else in the room like to come forward on Senate File 34? Sex offender registration, registrable offenses.
And we have someone online too, Mr. Chair.
And online, we do have, I believe, Mr. Hanson has requested the opportunity to visit with us. And so if you could please let him in, Lily. And also, I would just remind that we're on a very tight time frame this morning. So please be quick this morning, if you would. Good morning, Mr. Hanson.
Hello, Mr. Chairman and Senators. My name is Jason Hanson. I want to thank this committee for its work in realizing the unconstitutional treatment of Wyoming Statute 6-2 316A II and working to reclassify it in this Senate file. So it was brought about to fix discrepancies within the registry, and this was shown to be a large discrepancy in that it is classified severe J tier, registers 4 times a year, and can never ask for relief from duty. So you guys agreed to reclassify it, but put the 8-year age cap as stated, which is illogical and arbitrary as best, as the whole group of offenders was shown to be misplaced. Just as the whole group of offenders for the many more worse egregious offenses are placed in the H tier and allowed to get off registry after 25 years and are only monitored twice a year. And, you know, how is that fair that Wyoming currently takes it easy on the older offenders with younger victims and worse conduct, which are those first and second degree offenses, yet continues to make these low severity third degree offenses register 4 times a year for life? How is it fair that Senate File 34 would continue to make anyone convicted of 6-2 316A II who's over that 8-year cap register twice as long and never be asked for relief, even though if they had just chosen victims 13 through 15, they would have been charged with a first degree offense? Or if they had chosen their own child, they would be charged with a first degree offense. If they had chosen a victim 13 through 15 that wasn't their employee, they would be charged with a second degree offense. All of these are worse. They're all in the H category. They're all able to ask for relief from duty. That means that as written, this is just trying to put a Band-Aid over a bullet hole. And, you know, how can it be said to be protecting children when offenders are monitored more often and for life when they have older victims and less severe conduct? This is wrong in so many ways. It was recently ruled in South Carolina's Supreme Court in Powell versus Keel 2021 that it is unconstitutional to require lifetime registration for low-level sex offenders without a chance for judicial review. That lifetime inclusion of low-severity offenders, it renders the registry over-inclusive and dilutes the utility by creating an ever-growing list of registrants that is less effective at protecting the public or meeting the needs of law enforcement. If I could draw your attention to the memo I provided this committee titled SF0034, the first graph on that page was provided by the LSO office during the Joint Judicial Committee meetings on this subject, and it shows the medium H tier we've been talking about. They're able to be off after 25 years, monitored twice a year. No matter the age of the offender, Wyoming 62316A II, the third degree offense, is a lower level offense than every one of these first, second, and third degree offenses shown in this table I've provided. These sexual abuse of a minor laws had their severity determined when they were assigned statutory degrees of order. A third degree offense, a first and second degree offense are more severe than a third degree offense by rule of law. Therefore, a third degree offense should not be classified more severe and have to register twice as often as more severe offenses, especially when they have comparable offenses with younger victims and worse conduct. Since this committee has kind of struggled to understand the worst offenses, I'm going to go through each one. So the first one on the list is
Mr. Hanson, we don't have time to do that. So what I'd ask you to do is, if you would help us, we'd be glad to try to pitch in with you and take a specific look to Senate File 34. And as the language is contained therein, how would you recommend to us, or what are you suggesting as an amendment to this bill to accomplish some of what you're outlining this morning? And I wish we had time to spend way more time going through lists. We don't, unfortunately. We gavel in the Senate at 9:30 this morning. So how would you change Senate File 34?
Unfortunately, this is testimony that is relevant, sir. And I'm sorry, but on that list, the very second one in is a sexual abuse of a minor, where it was a parent that had sexual intrusion with a victim 13 through 18. The third one down on the list would be if I had chosen a victim 13 through 15 instead of a 16 or 17-year-old
I think the committee, Mr. Hanson, I think we get that. I think we fully understand that there are.
But not one of you have saw that, and your resident DA on the panel couldn't understand that. The Attorney General's office said that wasn't true last committee meeting. It is true, and there are. And one particular offense in general, 62315A II, the fourth one down on that list, it is if you're 17 or older and you have sex with a 13 or 15-year-old, then you're in the medium H. That was originally classified J in 2007, just like the other crimes. And then in 2011, your whole Senate moved to push that one down into the medium tier. It's a more severe offense.
Mr. Hanson, we remember that testimony. We get that.
This is the first time I'm saying it. So.
You actually said it in Douglas when we had a meeting up there. And we listened to that, and we understand that. We don't have time during this session to go back through these lists. I think that is a necessity. I think the Judiciary Committee will probably consider going back through H, I, and J, all of these offenses, because I think you make a very good point. Maybe some of them are in the wrong place. The only thing we can do this morning, Mr. Hanson, is to consider Senate File 34, which has reached this far. It's in front of the committee this morning. And so we have to do what we can do with Senate File 34 to make it as good a bill as we can. If there's a way that we can fix or amend, Senate File 34 this morning, and you have a suggestion of how you want us to do that, you're sure welcome to make that. But in the meantime, we have to cut this testimony short because we're running out of time to get upstairs. Does
I
that
would
make
like
sense?
to ask the Senate to amend, Mr. Chairman. And I provided a copy of that amendment to you and the LSO office. And I would ask to amend Senate File 34 as follows. Page 3, line 6, delete starting at if through line 7, ending at victim. And page 4, line 21, delete starting at 62316A double I through line 22, ending at W.SW. And this amendment would place the statute as a whole into the medium age tier so as to be more in line with Wyoming's stated registry purpose of being not to punish and for the protection of children and to facilitate law enforcement. I can tell you, you have, I was a 26-year-old store manager and had a consensual relationship with a 17-year-old employee. That puts me at exactly 8 years, 3 months. And as I read this, that wouldn't include me to be able to ask for relief from duty to register. And yet, if I had chosen a 13 through 15-year-old victim, again, I would be charged with a first-degree offense. I would be monitored less.
So, Mr. Hanson, if we eliminate the language that you suggested, I'm just trying to track this. If you get down to line 7, WS 62706, is that reference? Are we okay with that? I'm just trying to follow and make sure we understand what your amendment would do.
On page 3?
Page
4?
On page 3.
So there you would go down to victim. You would take out everything after 62316A double I. You would essentially eliminate the age cap.
Okay. Okay. Go ahead, Senator Case. Go ahead.
Mr. Henson, let me try to help you from here, just for 1 second, okay, if you don't
I
mind.
appreciate it.
Okay. So, Mr. Chairman, I think what we're talking about here is to go into 2 crimes, I'm sorry. 62316A, 62316 is sexual abuse of a minor in the 3rd degree. And A says, except under circumstances constituting sexual abuse of a minor in the 1st or 2nd degrees, an actor commits the crime of sexual abuse of a minor in the 3rd degree if, and it has a list. And what we had said before is, okay, you're right. You should be able to get off the registry if, but we're putting this qualifier about the age difference. And that's where I propose the amendment of 8 years. What Mr. Henson is doing is saying, no, the age shouldn't matter. It's really anything in 62316, little a, Romanet 2. And Romanet 2 is being 20 years of age or older, the actor engages in sexual intrusion with a victim who is either 16 or 17 years of age, and the victim is at least 4 years younger. So these are victims that are 16 or 17 years of age. And he's making the point that there are other crimes where victims are even younger, and they are not, and the registry implications are less. And I didn't have time to go to 62316. It's the same crime. It's the same crime. That's what we're talking about.
When I
here.
looked at it last night, it's the same one. And so,
Yeah.
Senator Case, thank you. That's very helpful.
Is your
And-
mic on, sir?
And it is. I don't.
There, I'm
Is it
sorry.
working? Mr. Hanson, I think we're getting there. Appreciate your patience with us and your help this morning. And I think the committee is inclined to consider your amendment. I'm going to offer you any final thoughts, because we do have to move on. We're just about out of time, and I'd like to move this bill forward and provide some help. So, final comments.
Just that, the age difference of offender to victim wasn't used to determine any severity rating for any of Wyoming's current crimes. And, this crime particularly, if you look at other states around you, there's a number of them that it wouldn't even be a crime in. Others, they're really low. They can ask to be off after 10 years. And so this crime was never, the severity was never put against the first and second degree offenses I've spoke about. And so, again, it's one thing to have your public criminal record made more accessible and periodically update your address. It's entirely another to be placed under a probationary surveillance system in perpetuity, which is essentially designed to ostracize people. One other thing is, this would stop your reporting agents from being paid to over monitor low-level offenders 4 times a year for life. So, sheriffs in small counties that have to register these people, would be able to concentrate more on offenders that actually are a danger to society and more severe offenders.
It's a very good point, Mr. Hanson. I'm going to have to
I understand.
shut you off at this point. It's been very helpful, and thank you for your patience. Appreciate your help, and I suspect we'll be taking up many of these issues that you've raised. We'll have to do that at a future date, but thank you for joining in this morning. Further testimony, I have somebody else. I assume that is somebody related to Jason. Okay. Okay, I think we're going to close public testimony. Committee, what's your pleasure on this bill? What is your pleasure on this bill?
Mr. Chairman, I'll move to pass so we can discuss it.
Okay, moved by Senator Case. Discussion.
So, Mr. Chairman, what the bill does now is say that in this case where someone is 20, you have to be older than 20, and the victim is 16 or 17, that you can get, if you weren't 8 years older than the victim, or if you weren't 9 years older than the victim, you can get off the registry in 10 years. That's what the bill does with the amendment. And I think what Mr. Henson's amendment is saying, hey, all those people that are 20 years of age or older and engaged in sex with someone that is 16 or 17 should be able to petition to get off the registry. That's the gist of the two choices. And his point is solid, that there's a whole bunch of other crimes that are treated unequally. And we don't have a real table and chart of that, but there is an equity argument that is very, very large. But I think it comes down to, and in his case, he was a store manager, and he was more than 8 years older than the victim. And the victim, I believe he said, was 17, but it could have been 16 or 17 under this deal. So it was one or the other. And that's the question, is do you want to have those people register for life or not? Existing law says register for life. Our bill has a carve out for the 8 years. Mr. Henson is suggesting make the carve out for any age difference. That's the choice on the table.
Appreciate that, Senator Case. Committee, I'll just speak from my standpoint. I'm compelled by what Mr. Hanson said, but more just because of looking through these statutes and trying to get up to speed on them. There's inconsistencies, and this is one of them. I don't see any reason why we could not suggest upstairs that this is a crime that you should be able to petition to get off of a lifetime registry, in my opinion, but that's just my opinion. What are the feelings of the committee?
So, and Mr. Chairman, if that's the case, then we would adopt Mr. Henson's suggestion, and it's for any, it's statutory rape, and where the perpetrator, though, is in a position of authority. I think that's at least what this section says. In this case, it's a store manager. Is that really a position of authority? Well, maybe to a 16 or 17-year-old child it is. So, yeah, that's it. If we, I think we need, this is, I hate this topic, and I know we all do,
Yeah.
but this needs work by the committee, the whole area, and relates to, we keep adding things because it's very popular to do, like Senator Ellis's bill. So what we could do, we could adopt Mr. Henson's motion, but, and I'm happy to offer it.
I don't have it in front of me, Senator Case, but my understanding is that's a 10-year report.
Are you talking this one?
Yeah, but at that point, you can petition to get off. Is that correct? Or is that right out of the blocks?
I think it's lifetime. I think he's under a lifetime restriction, and this is allowed.
I think he is now, but if we were to adopt this amendment, there would still be a registration, but you could petition to get off.
At 10 years.
10 years.
I believe.
I believe that's what we would be doing, and 10 years to register, then you petition to get off. That seems very,
Let's go for it. I'll move Mr. Henson's proposed amendment.
okay. And so Lily and Pierre, do you have what Mr. Hanson suggested? Lines 6 and 7 on page 3, and then it goes to line 21 and 22 on page 4. Okay. Committee, does everybody understand what we're doing here? Okay. All in favor of Senator Case's motion, say aye.
Aye.
Any opposed, no. That amendment has passed. Further discussion? Are you ready for the question? Lily, please take roll on Senate File 34.
Senator Case,
Aye.
Senator Cooper,
No.
Senator Furphy. Senator Schuler. Chairman Landon.
Aye. Does anybody have, just dying to present this up on the floor? Senate File 34? Okay, I'm sure you're all right behind me.
Quite a ways.
Senate File 34 will go to the
Mr. Chairman, as
Senate.
we present it, we ought to make a plea that this is a tangled and confusing mess. But we came down on the side of 10 years, obviously clean living for 10 years, and
Fix what we can while we can,
Yeah.
as we're here, but we recognize that we've got a lot more work to do on these statutes. I think none of us wants to go back into this set of statutes, but I think they could use some cleanup. So committee, here's what we look at for next week. We've got the hemp bill up on Monday, along with a bill from Senator Nethercott. Tuesday at noon, plan on a meeting because we have bills we're going to have to try to get to. We'll meet again Wednesday morning, probably early, and we will still have 10 or 12 bills at that point. I'd like for everyone to save Thursday at noon because some of those bills include a couple of property tax bills that the Senate may want us to get to and get out with. So it's going to be a very busy week next week. Sorry about that, but we've received a lot of bills.
when's the last day to come out of committee, Mr. Chairman?
I thought it was next Thursday.
So it's
Oh,
Wednesday.
it's Wednesday, so Thursday isn't going to work.
Yeah.
And so that puts us up against the blaze. And Pierre, if you would check and see if there's another time, Monday, Tuesday, Wednesday, that doesn't conflict for us five, at least we would give ourselves an option at a fourth meeting for the week. We will meet Monday, Tuesday, and Wednesday.
And Mr. Chairman, you're on corporations, and we also have a heavy load, and we only have one meeting day next week, and didn't get, so we met yesterday. So Tuesday, we might meet 3 times on Tuesday. It's very possible. So, and you don't have to be there, I understand, but I will not be able to attend this committee.
We may have to split.
We may have to split.
That's a very good point, Mr.
Yeah.
Chairman. So we'll work that all out. I know the Senate's going to want to do as much work as humanly possible. And so to all of you visiting the committee this morning, that's what we face going forward. And we'll keep you posted. But lots of work to be done next week for sure. Thanks for the effort this morning, committee. Let's go upstairs. The meeting is adjourned.